And I have to say that if I was in the White House, if I was in the Obama administration, I would not be comfortable with how the last 3 days went. Today was day 3 of the hearings on the Patient Protection and Affordable Care Act, also known as Obamacare. Today there were 2 big questions that the Supreme Court was addressing. The first is an issue called severability. If the individual mandate, which compels every American to buy or secure health insurance, is struck down by the court, does the rest, the entire act, have to fall as well? The second issue that was addressed today was the law's Medicaid expansion. So Medicaid is the joint federal-state program providing health care for the poor. And what the challengers were arguing here was that although the states had voluntarily, once upon a time, entered into this program, the government, by forcing them to expand the Medicaid program, was unlawfully using its spending power. Essentially, the government was coercing the states. My big takeaway from today is that if the individual mandate is ruled unconstitutional, the entire healthcare law is likely to go down as well. This is particularly due, I think, and this is often the case with the Supreme Court, to how is Justice Kennedy going to vote. Justice Kennedy's big concern today was basically the issue of judicial restraint. Would the Supreme Court be overstepping its powers, its judicial powers, by striking down the entire law, or would it in fact be overstepping its powers by just picking and choosing which parts of the healthcare law to uphold and strike down? And Kennedy's position, it seemed to me, and he expressed this in several ways, was that in fact the more restrained thing that the Supreme Court could do would be to strike down the entire law. And the argument along these lines would be, by giving Congress half the law, giving Congress this sort of shell, you take out the individual mandate and then you leave these other pieces, that's a mess. And in fact, that's something the court shouldn't be doing. What the court should do, the modest thing, the restrained thing for the court to do would be to strike down the whole law. Now that we've concluded the 3 days of arguments, at this point the decision, it's in the hands of the court. We have to wait and see. We expect a ruling the end of June, at the end of the term. This is typically what the Supreme Court does. They save the biggest, the blockbuster decisions for the last week, maybe the last day. And I have to say that if I was in the White House, if I was in the Obama administration, I would not be comfortable with how the last 3 days went. That doesn't mean that the administration's going to lose. It doesn't mean that the mandate's going down. But I think the administration had reason to be more confident going in, and they have to be very concerned with how it went. And I don't just mean that the Solicitor General had a bad day. I mean that their arguments were nowhere near as strong as they thought they were going to be. And that the justices, and not just ones who are obviously conservative like Scalia or Alito, but swing Justice Kennedy poked real holes and had real fundamental concerns with what the government was arguing. And if I was in the White House, I would be concerned about that.